All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning and welcome to the Florida Supreme Court. Our first case today is Publix Supermarkets versus Goga, number 2024-0669. Whenever you're ready.
Good morning. May it please the court. Edward Geddes on behalf of the petitioner Publix Supermarket. With me at council table is my colleague Blaine Udis. Let me dive right into the narrow issue that we have before us today, which is the proper role of an appellate court reviewing the sanction imposed by a trial court for fraud upon the court. In this instance, Publix contends the 4th District overstepped the proper role of an appellate court when it reconsidered the propriety of the dismissal for fraud upon the court, especially when one considers that the 4th District affirmed virtually everything the trial court did in reaching its conclusion that a fraud had been committed by Ms. Goga.
Can I ask you a question? So, it kind of goes to jurisdiction, but it also just sort of goes to kind of what we're here to decide and to do.
Of course.
Reading your brief, and I understand kind of your problem with the opinion, and I understand I understand that it seems like a flawed piece of work, but the way you described the case, it seems like we have to kind of read more into the face of the opinion that's there. So I didn't, and so correct me if I'm wrong about this, I didn't see anywhere in here where the court says that liability was still contested, and I don't see anything about the appeals court sort of purporting to decide, the credibility of the plaintiff. And so it seems like for us to sort of view the case the way you do and kind of set up the rule that you're asking us to apply, we basically have to go beyond what's in the opinion itself. Could you respond to that?
Certainly, Your Honor. I'll invert the two issues because I believe the second one is perhaps easier to address. On the question of the court making what we contend are these fact findings, engaging in fact finding, I think it's evident on the face of the opinion that the court at the 4th District was reaching a conclusion about the effects of Ms. Goga's dishonesty on the entirety of the proceedings, and somehow reaching a conclusion that the trial court never reached. There was never in the record any finding by the trial court about how her dishonesty could be cabined in any way, shape, or form.
Well, in fact, there was a finding directly to the contrary.
Yes.
Because the trial court found, based on the totality of the circumstances and evidence before this court, it has been established by clear and convincing evidence that the plaintiff's lies and deceit permeate the entire case, and that she has intentionally and repeatedly misrepresented herself as overly impaired in an effort to perpetuate a fraud on this court. So there was a specific finding that it permeated the entire case.
Absolutely, Your Honor. Absolutely. You anticipated my next process, my next thought.
Do you agree, though, that for us you wouldn't know from the four corners of the opinion that liability was still contested?
You are correct. There is nothing in the four corners, but
where does that leave us on jurisdiction? Because if I read the opinion, before I knew what was going on, obviously now we have the whole case and we understand that liability was contested and everything. But if I'm going through the exercise at the jurisdictional stage of just reading this opinion, and I see the reliance on the 50 CA case, Jimenez, I guess, and I see the description of that case where liability was not contested and it wasn't contested that they had, medical costs and whatever. And then I see a case that says, applying the reasoning of Jimenez, we say she can't claim this, but she can claim that. I mean, wouldn't the most natural reading of this be, and it seems like this was a mistake, but if I'm just focusing on the four corners, wouldn't the most natural reading of this opinion be that those things weren't contested in this case either?
I think you can't, well, no, I don't think we can't draw a conclusion one way or the other. I will concede that point to Your Honor. But our contention isn't that conflict arises because of what Jimenez holds. We contend that conflict arises, and this is the second prong of Cartonis, which is where you have identical facts, or substantially identical facts, and you have diametrically opposed conclusions as to the outcome.
But isn't the liability being contested? Isn't that the identity of facts that you're relying on?
But I'm not comparing Jimenez with Goga. I am comparing Jimenez with Willie Kuntz, and now we have the benefit of also the Fifth District's decision in Epps. In both of those cases, in fact, in both of those cases, the exact same argument was raised by the plaintiff, relying on Jimenez, ironically enough. They both said, you shouldn't dismiss, make it a narrower remedy. And both the third in Willie Kuntz and the fifth in Epps said, no, we're not going to disturb the trial court's jurisdiction, or excuse me, the exercise of discretion, because there's plenty of evidence to support what the trial court did, and we're not going to parachute in and change it.
But even in your briefing, you say that in a case where liability isn't contested, that it could potentially be an abuse of justice. And so I don't want to. I mean, I understand that there may be a benefit to this. Seems like just a bad. I don't know what the court was thinking, but if I'm just reading what's here, and if part of the jurisdictional thing and also the precedent, if I were reading this case going forward, I would read this case as standing for the precedent that when liability isn't contested, and again, four corners, because I need to know a lot more from outside the opinion to know why this is as bad as it is, right? If I read just the four corners, I would think, well, we have a case where, based on the way they're using Jimenez and describing it here, liability isn't contested. The fact that she had medical treatment wasn't contested. So you slice off the stuff where the lying is relevant, and for the stuff where it's not contested, you move forward with that. I mean, that seems to me that that's what this case stands for. And for us to kind of do what you want us to do, we have to kind of recharacterize the opinion in a way that's to make it say more than it does.
I think if you look back at, well, I understand the point Your Honor is making, and I think that where the court should be exercising its jurisdiction is to reconcile the outcome here, which I think Your Honor has already acknowledged is difficult to understand, with the correct outcomes that happened in Willie Kuntz and in Epps, based on the same facts. All right, and that's where I think the jurisdiction...
Let's take Epps off the table because, it is subsequent in time. It sounds like what you're really arguing is that we need to answer this question jurisdictionally. Is a matter like this where liability, say, we can't decide on the basis of the four corners of the opinion what the status of liability is in terms of its degree of contestedness. Is it going to come out differently in the third than in the fourth? That is one way for me to sort of articulate the jurisdictional question. It sounds a little bit like you aren't able to give a conclusive answer to that to the chief. I want you, perhaps let's take another shot at it. Is that your argument, that if this case were presented in the third, we would expect it to come out differently than in the fourth?
Absolutely, Ron.
Okay.
Absolutely.
And what about the Chief's point about how you might, distinguish on the basis of the absence of a liability finding in the four corners of the opinion? Because I would bet that's what you would argue to distinguish it, right? If you had the same case in the third.
I would. It has, and it is in fact what has been argued. So I'll concede that point that it's not there. But we do have these, and I don't want to go out. I want to be careful about going outside the record here and what I know is happening with this decision already.
Right.
So, I apologize, Your Honor. I'm not sure that I can. I'm not sure I can directly answer your question, except to say that I think it is. I think it is as fair a conclusion if you look at how Goga, or how the Fourth District describes the case in Goga, leading up to where it cites Jimenez, that it is differentiating. The only thing it picks out as being uncontested, is this question of supposedly the objective medical damages. It seems odd for the Fourth to have picked that issue as being not subject to her testimony because it can somehow be objectively verified, and have ignored or have not discussed, for example, how those damages could have been caused by Publix in the first instance.
That sounds to me more like it sounds like a more complete answer than what you said about it not being in the four corners. You're kind of saying it is in the four corners, but I'm looking at it's like a figure in a painting that casts a shadow, and you're saying that figure is in there because I see the shadow or something like that.
I am drawing my own. The Chief drew inferences about how you read Goga as it's written because they cite to him, and as therefore they must have. And
they don't just cite it; they say, I think they.
And they talk about the
bunch
facts.
of boilerplate about the standards, which you say basically there isn't. Because I'm just trying to figure out what we're doing here, right? Mm-hmm. Error correction versus truly clarifying rule of law, whatever. And so all of this is boilerplate. You say that the DCAs are all in agreement basically about the standards. And then we get to finally the last 3 or 4 paragraphs where they're doing all the work, and they conclude by saying adopting the 5th District's reasoning, comma, blah, blah, blah. And so I then go back to how they described it, and they talk about the reasoning being where when this isn't contested and, we carve out the contested part and we leave the uncontested part. So, I understand. It may be that the world is a better place if we quash this because it just doesn't seem like it's a good opinion. It seems like it ignored sort of what was going on. But if we're being, sticklers about jurisdiction and what we're really doing here, it seems like we're going to have to kind of reshape what the opinion says to get there.
Well, I'm sorry, Your Honor. Go ahead.
Could I ask a question that I think it takes a little different tack than the way you've analyzed it? But what I'd like to focus on is the discrepancy between what the two opinions say about balancing the policy favoring adjudication on the merits and the importance of maintaining judicial integrity, or the integrity of the judicial system. Now, that seems to be the reasoning process that is driving the decision in Goga, this balancing. Now, I don't see that in Wiley Kuntz, and that's actually, they didn't see it either. In Goga, they kind of say, well, they don't talk about that. And I understand you don't rely on that as a basis for conflict, but it seems like to me, when you look at the two opinions, the way they're analyzing it is kind of fundamentally different, because one talks about that and the other does not. One just they talk about other things related, but that when it comes down to that balancing, which basically is the principle on which they are deciding, Goga is deciding it, that's absent from the other case. Why isn't that in itself a conflict?
It is a conflict, and it is, I know again, Epps comes after the fact, but Epps squarely addresses the balancing of the two policies.
Well, I'm kind of still on the jurisdiction question.
Right, but I think that creates conflict, how the 5th District applies that balancing and how the 4th DCA in Goga applied the balancing are diametrically opposed to each other.
Well, but I think it sounded like what the question was going to was whether the balancing has to happen, and then there's the application. So if you go back to the First Circuit case, which seems to be the fountainhead of this whole thing, and they make the distinction when they're talking about abuse of discretion review. They're making the distinction between, one way for a court to abuse its discretion is to kind of balance the wrong things, or not to put things in the balance, to not consider factors that would be relevant. And then the next layer of potential abuse of discretion is when you agree, the appellate court agrees that the court considered the right things, but then applied them in a way that abuses discretion. And so I guess one question could be, is there a conflict with this case and some other DCA case at the level of what are the relevant considerations, or does there have to be a balancing at all? And then you get down to the next layer of, okay, assuming that we have to balance and assuming that we agree what the relevant criteria are or considerations, then did we apply it in a wrong way? And it seems like if we get to that level, then there has to be a difference in the facts for there to be a conflict, because you'd have to be agreeing on the test, agreeing on the need for balancing, and then just getting diametrically opposed results in the application.
But look, could I ask this? I think it's a follow-up to what the Chief is saying. In Wiley Kuntz, is that the way you say it?
I've always said Wiley Kuntz, but it could be.
I'll say in the 3rd DCA case, that's the conflict case, the asserted conflict case. Is there really anything about balancing?
No, they do not engage in that analysis.
Okay, so one court is saying you've got to do this balancing, and the other court is just ignoring it. So that seems to me to be a basis for saying that there's a conflict.
But then the irony would be that we would agree with the 4th that you have to do balancing.
Well, we may or may not.
We'll see.
I mean,
we'll see.
I mean, okay,
Counsel, would you think?
We'll just redo the whole test.
Would you think that perhaps, the test is a federal standard, right? It's never really been adopted or mentioned by this court, to my knowledge, the balancing. In fraud case?
Never by this
never
court.
Here. I think it came from a federal case in the maybe 80s, 90s.
Audi, yeah.
Would you say that perhaps a difference here is that whatever the standard of review is that the DCAs have created, which appears to not exist in any other area of law? I mean, I think in this case, they said they applied the abuse of discretion to the legal conclusion. I mean, I don't know any other way, any other place we do that. That's not really, we have abuse of discretion for matters of discretion, and we have de novo for legal conclusions, and we have competent substantial evidence for facts. It's not, this is a very unique standard. Do you think that the problem is, that none of the DCAs really agree on what that actually looks like? Problem A. And the second part is that, particularly between Goga and Willie Kuntz, they focused on this sort of stringent review on both whether fraud existed and the sanction in Goga. So they're reweighing, as you said, they're applying this very strict standard, they're applying this balancing test to the sanction. None of the cases from the 3rd seem to do that. They apply that strict standard to the question of if fraud exists, but once they determine fraud, it's just kind of a standard, would a reasonable judge, using the discretion, find the sanction appropriate? And if so, it's affirmed. They don't really have a heavy analysis on that part. They don't do the balancing test. They don't do any of that. Do you think perhaps that is one of the bigger distinctions in the two?
I think that's a fair assessment, Justice Grosshand. If I could maybe phrase it slightly differently, but I think it goes to the same point, which is this idea. The one thing that Willie Kuntz and Epps on the one hand and Goga on the other hand are at odds on is what happens after there has been an affirmance of the fraud on the court.
Because that's the same in Goga and Willie Kuntz.
They share that in common.
Yes.
We have concluded, we have gone through the tests, there has been the evidentiary hearing, we've made the analysis. We are comfortable saying the trial court correctly found there was fraud. Now, what happens at the next step with the sanction that's imposed? And what Goga seems to suggest is that it's not a traditional abuse of discretion standard. You know, what do reasonable minds agree on, don't agree on? It seems to parachute in and say, no, we're substituting our discretion. And the irony is, and we point this out in our brief, so the irony is, oh my goodness, I'm almost out of time. The irony is that the fourth DCA itself, in prior cases, in Bass, had said, it's not our role, once you get to the sanction, it's not our role to substitute
so can I ask you
our
something
judgment.
on that? In terms of like going to the what are we doing here question, do you see what the fourth DCA and Goga, because they say it's based on the specific facts of this case, but if you look at the analysis, it seems more categorical. In other words, if the intentional misrepresentation and lie, not necessarily misrepresentation, goes to only a category of damages, then the trial court essentially does not have the discretion to dismiss the entire case. That seems to be more of a legally insufficient sort of analysis. So is it truly a misunderstanding of the abuse of discretion standard, or is it the way this is playing out in the district courts? It's they're conflating whether something is legally sufficient to warrant dismissal with the trial court's discretion to dismiss something.
That is a fair characterization, I think, Your Honor, because I think that's it's the only way to explain how they got to where they got. When I say they, I mean the panel below, because they have to have gotten to a position where they thought the trial judge applied the wrong test. Right? When they got to the question of what's the sanction I'm going to impose, they applied the wrong test because, and this I'm reading a little bit into this, is so long as the lie can be tied to a specific issue, it doesn't matter for anything else, and therefore the rest of the case should be allowed to go forward. That's a conclusion they come to. And I don't know how they reached that conclusion given the factual findings that the trial court made, that the fraud permeated the entire proceeding.
Yeah, so let me ask you, because that was another nuance in your briefing, is it seemed like, and if we're going to kind of make the world anew, maybe this can be part of our new test, is you suggested at one point in your brief that part of what makes something a fraud on the court, as opposed to just, oh, they lied in an answer to an interrogatory or whatever, is that by definition a fraud on the court permeates the entire case, which isn't literally, and I know that this quote-unquote test is just something that was adopted from case law or whatever, but
it is, yes.
In your briefing it seemed like you kind of, at points you sort of incorporate that into the fraud on the court test, and if that were part of what the permeating the entire case, if that's part of what the court has to find, and if there has to be competent and substantial evidence for that, then it does seem like logically, if the fraud really quote-unquote permeates the case, then I don't see how dismissal couldn't be on the table. I don't even really, I mean, arguably you would have to dismiss the case at that point. But I mean, should that be, is it properly called a fraud on the court if it can be compartmentalized? I mean, so is that another way to slice it?
I think the case law is too inconsistent, respectfully, Your Honor, to say that all courts uniformly agree upon that. I have seen in multiple occasions where the DCAs have said that the fraud, and I think what the DCAs struggle with is, okay, how do we reconcile somebody with a faulty memory, somebody who just doesn't remember something that happened 10 years ago? It has to be serious. Isn't
this what trial courts do all the time?
All the time.
And for me, this is kind of a red herring. Whether or not it can be cabined logically is an interesting academic debate. But in the real world, trial judges do this all the time and exercise traditional equitable powers, and they don't need to cabin it all the time. We don't need to answer that question. The question is, let's accept as a postulate that any lie in a deposition, however minor, is indeed a fraud upon the court, because it is. It's a lie. Okay. The question is it a fraud upon the court of such magnitude that it requires dismissal of the action?
Correct.
Which is a separate question and doesn't require this line drawing, and is an exercise in the discretion of a trial court. If someone is bribing jurors, for example, another fraud upon the court, right, that would seem to, eracinate the entire, proceeding in such a way that we'd have to just like dismiss it in a way that a very grievous and repeated falsehood would. I mean, isn't that a better way of dividing the question than to debate whether or not we can cabinet?
I think that's fair, and particularly when you think about how this particular case played out, because what the trial court did correctly was it gave Ms. Goga the opportunity at an evidentiary hearing to come forth and explain her prior testimony. And instead, what the trial judge concluded is she essentially doubled down with her dishonesty, came up with absurd explanations for why she had lied, and that led the trial court to make its factual finding that she is willing to lie to suit her needs, right? Pretty much in all aspects of this case.
And isn't it very difficult to see, once you conclude that there's a scheme to defraud,
Yes.
And there are lies, so there's this pattern of lying, which is documented and undeniable, about the extent of injuries and the extent of her suffering. To think that even that sort of lie would not affect the claim for medical expenses just seems to me to be extraordinarily fallacious, because obviously someone who is making up things about their ability to function and how they can perform and how much pain they have and all that will tell consistent lies, most likely, to the healthcare provider that they go to, and they're going to seek treatment. And this is not, obviously, I don't think most people do that who are injured. I think they tell the doctor the truth because they want to get the best care they can get. But we know that people will run up medical bills as part of the overall effort to inflate the pain and suffering damages. That happens. And so to somehow to compartmentalize that seems to be to flee from the obvious reality of what the person would be doing.
If I tell my doctor that I am still in perpetual pain, and the doctor then prescribes another 20 sessions of therapy, the bills have been inflated precisely because of that, because I lied to my own doctor about what I'm experiencing. And that's why at its most basic level, the assumption that there's objective evidence of the medical damages just because there are bills you're right. I think the term you used is correct. It's fallacious.
We can write a 2-page opinion saying that they misapply the abuse of discretion standard. My problem is, is that what we're here to do? I mean, this is like a second appeal. So you can have, that was semi-rhetorical. So you can have 2 minutes to finish up, and then you can have 3 minutes for rebuttal.
Thank you. I think the court senses the problems that exist with the Fourth's decision. And I understand the court's jurisdictional concerns, but I think there are ways of reaching this jurisdictionally under the broad rubric of Cartonis that lets you resolve this. We very consciously, because of these very complicated issues, we very consciously tried to keep the issue narrow before this court so that it could decide the case on the narrowest grounds possible. Ultimately, at the end of the day, that's your call. But I think there are ways of addressing the outcome here based purely on the Fourth DCA's improper analysis or review of the sanction that was imposed by the trial court and substituting its own fact-finding and its own discretion for that of the trial court. So we respectfully ask that the court quash that portion of the Fourth District's decision and remand.
Thank you.
Good morning, Your Honors. I'm Annabelle Majeski, representing Ms. Goga. If it may it please the court, first of all, I'd like to point out that the Fourth District did not reassess Ms. Goga's credibility, and we are not disputing the fact that there was fraud on the court. I would focus on the fact that of the balancing test as to whether adjudication on the merits balanced against maintaining judicial integrity. And I would suggest that the balance should be in favor of adjudication on the merits were at all possible, which would go to the fact that she still had a viable claim as to her medical expenses. I don't think that it's
Counsel,
contested.
could you
counsel,
address-
I mean, let me just go back to what I just asked opposing counsel. I don't see how the lies that we know were told and that you don't dispute. Okay, that
Right. We do not dispute
that's set. The table's set on that. I just don't know how we can logically separate that out and say, oh, that's not going to have anything to do with the medical expenses. Because obviously, a person who has had the good fortune of slipping and falling in Publix, okay, sometimes that might be viewed as good fortune, very deep pocket, and then goes on and buys their wine without any obvious indication of any problem, might decide that this is an opportunity to get some real money and tell some lies about how this fall has affected the plaintiff's life. But the idea that would not have an impact on the medical expenses, I just struggle to see in any sane world where a person who has such a scheme would not carry out that scheme also in the way they're obtaining the medical care. I don't follow it.
Maybe I can
Help me.
Help Your Honor. Yes.
I'm
I
in
will
desperate
try.
need of help.
All right. So she fell in Publix and she injured her back. She had surgery. She probably had all of those things that she, a year later, said she continued to have in recuperating. She couldn't lift things. She couldn't, all the things that she claimed she could no longer do. She probably, after the surgery, could no longer do those things. Her lie is to the fact that she lied about the fact that the after effects of the surgery continued way beyond when obviously they did not. So we still have, if you go back to the original injury and the original medical treatment that she had, that can be separated from the continuing effects of the aftermath of the back surgery, which was the result of the injury. I don't think that you would go to the extent of lying and submitting yourself to back surgery and months of recovery just to get money from Publix. I hope that helps Your Honor compartmentalize it a little bit more.
But I mean, even if we look at what you're saying in the most sympathetic light, it would be a pretty aggressive application of abuse of discretion review to say that if you accept the premise that, you have to consider both things, which is what you started with, and you put all this stuff in the balance, and then the court just makes a judgment call as to whether dismissal is warranted. I mean, how could that possibly be an abuse of discretion unless it's uncontested, which is why, if you look at one way of reading this opinion is they compare it to a case where liability and the cost of the plaintiff's medical expenses were uncontested. I mean, you could imagine in that situation, but it seems like that's not the case here. And so given that that's not the case here, how could it possibly be an abuse of discretion for the trial court to have done what it did here?
I guess under the narrowed, to me it seems that the Fourth District puts an emphasis on the balancing test and didn't reach the conclusion that the trial court did not do the balancing test.
So do you agree? I mean, do we need to kind of, is the idea that abuse of discretion, and once you get to this point is, could any reason, because there's abuse of discretion at the level of what did you consider, right? But then when you get to applying the correct things, could any reasonable judge have done what this judge did? Are you saying that there needs to be a different test in this context?
Well, I'm relying on the balancing test, and that's why you get different results, because it's fact intensive on each case as to the injuries claimed, what the lie does, how does the lie permeate the entire case, and of course if the lie permeates the entire case and there's no claim that can be separated out, then dismissal of the entire case should be warranted. And those are the cases relied on by the petitioner, such as Herman v. Intracoastal and the other one. But I'm saying that as far back as Kornblum v. Schneider, the fourth DCA case, that's in 1992, there is a thing that dismissal of the entire case has been upheld when it permeates the entire case, but in others where the fraud or other misconduct pertain to only a part of the claim, dismissal of the unaffected legitimate part has been held to be too severe.
Well, okay, so let's just break this apart. In your view, the obvious finder of permeation is the trial court judge, right?
Yes.
And is that a question of law or fact or both? The question of permeation.
Well, it's a question of fact to the point where the appellate court determines whether there was substantial competent evidence.
Right. Well, but I'm talking about the trial court's finding, right? Let's take and put aside the fact of the lie, right? Now the question is it a lie that permeates through the case? Right. I'm asking you what kind of determination is that? We agree that it resides with the trial court. How does the trial court make that decision in your view? What's the work that the trial court does?
Well, of course, they're assessing credibility and all that.
Well, no.
I think it's
assessment
still an abuse of
credibility
discretion.
goes to the lie. Okay, so we're done with our credibility assessment.
Okay.
Now the trial court is deciding whether or not the lie is so severe that it permeates through the case. Now my question is, what is the mental labor of the trial court in making that finding?
I think it would be more a question of law.
Okay, so now we get to, let's assume the trial court makes a finding of law that the lie permeates the case. That is now on review, right, before the district court.
Correct.
Why is that not subject to just de novo review?
Well, if it's a question of law, then yes, it is de novo review.
Isn't that much more simple than the mess that we're currently wading
Yes.
through? Okay.
And even more simple than the narrowed abusive discretion standard, which we applied to see whether there was fraud on the court.
On the narrowed abusive discretion standard, what's the ultimate source of that?
I think the ultimate source of that is it goes back to the constitutional right to redress of injuries and access to the courts. I think that's what made it a narrowed abusive discretion.
I mean, what court did that come from?
That one I can't answer that, Your Honor. I don't know for sure. It's just that it's been around for a while. And
I believe it was the fifth DCA.
There also was a very learned second DCA opinion that I think talks about the narrow use of discretion.
well,
I think we had precedent that
I think this is one
that
that's the
was
wisdom
following
of the ages. I mean, it's in 1,000 cases.
Why do you see permeation as a legal issue rather than a factual issue?
I'm sorry, Your Honor.
Permeation, whether a lie permeates the entire proceeding, why do you see that as legal versus factual?
I guess because you've already determined what the facts of the case are when you determine that there was a fraud. But then you have to see how does that, if you're applying the fraud to determine whether it affects the entire case, what affects the entire case would be a question of law. Because
So you see it more as a question of law in the sense that if the lie goes to only one category of damages, you can't dismiss the entire case, and that's a legal conclusion that should be applied across all districts versus giving the trial court the discretion to look at the proceeding on a case-by-case basis, fact-by-fact basis, whether this lie and surveillance post-accident would in fact affect a defense of the medical treatment that preceded that. In other words, the trial court couldn't look at the facts of that case and make that determination.
well, they would have to look at the facts, even if it's a question of law, because it would be the facts that determine how they're applying the law.
But in terms of applying the principle, the trial court would be precluded from dismissing if it was a categorical legal conclusion. Is that your position, that in determining whether dismissal is appropriate, trial court's discretion is bound by this legal sphere, which includes this rule that if the lie goes to only one category of damages, trial court can dismiss in any case?
I don't think I'm going that far. I think I'm saying that if the balancing of the factors shows that it does not permeate, so somebody has to do an analysis as to whether a finding that it permeates the entire case is correct, and that would, in most instances, be the appellate court. So if they're reviewing, at the moment it seems that everyone's reviewing under the heightened narrowed abusive discretion standard, and it would be much easier if they said, yes, we agree that a fraud was committed, but as to whether the fraud permeates the entire case is a question of law, because the dismissal is such a death knell and should be used sparingly.
So if it's a question of law, then what is your legal standard to apply to whether or not something permeates the entire case?
Would be de novo.
No, not standard of review. What is the legal standard for whether something permeates the entire case? It's not discretionary, it's not fact-based, so there must be some legal standard that would govern the trial court's analysis, and what would that standard be?
I don't know. I'd leave that to you all.
No, but I mean, so if you finish the sentence, a fraud permeates the entire case when ... Like, what's the ...
I guess when there's no part of the case that can be separated out, that's not affected by law.
In a case where liability and the amount of medical care is uncontested, would the fraud permeate that part of the case?
If it's uncontested, no. You can still go ahead and determine what the damages are. Now,
but then if liability is contested, and if the trial court here basically says this plaintiff is such a liar, starting from the minute that she slipped on the soap to picking her kids up without pain, she's such a liar both in the discovery process and at this hearing that we can't believe a word that comes out of her mouth. I mean, doesn't that permeate the case?
Well, in that case, if it's found, those are cases.
That's what the trial court in this case found.
Well, they just said that it permeated the entire case.
And they said that they said, look, the video showed her immediately after the accident she was fine. She was fine in everything. I brought her in here for an evidentiary hearing, and I didn't believe what she said. She's a liar. We can't believe anything she says. It permeates the whole case. Case dismissed. How could that be an abuse of discretion?
First of all, Your Honor, the video that you're talking about is that was in the store that she did walk away after that she had slipped and fallen. But pretty soon after that is when she started receiving the medical treatment. When she started lying about the after effects of the surgery, basically, of the injury, surgery, and then the after effects of the surgery, was at least a year after she had the surgery.
Did she make any statements about what she experienced at the time she fell and shortly thereafter? Weren't there some?
Yes, she did.
There were some statements there that weren't consistent with the video, weren't there?
Yes, she said.
Okay, so it goes back to the very inception of the whole thing.
Isn't the right answer supplied by Willie Kuntz? The movement must prove by clear and convincing evidence that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability to impartially adjudicate a matter by improperly influencing the trier of fact or unfairly hampering the presentation of the opposing party's claim or defense. Isn't that the legal standard in the case law that is in the conflict case, but absent in this one?
Yes.
I mean, that sounds like a legal standard to me. Like it is a fraud upon the court meriting dismissal when ... those things are true.
Yes.
Okay.
Yes, it was up to Publix to prove that she had sentiently set in motion a scheme to defraud completely. Mm-hmm. And my point is, at the very beginning, I don't know that it's very clear and convincing that she set out a scheme to defraud them by, claiming that her back was injured and having back
But that's
surgery.
not what the fourth found. They didn't say that she didn't do that. They affirmed all of those things, right? They just said, oh, we disagree how bad it was, the sanction. We disagree with the sanction. They did not do an abuse of discretion review. They did not talk about a reasonable action of a judge. They just basically said, we disagree.
Yes.
Well, they talk about it, but then arguably they trip at the end and misapply it because they quote this, exactly what was just read.
Yes.
It's in here in the fourth. They quote the no reasonable judge standard, and then they get to the end and they do a face plant. And the only way to understand it is that they either just fell asleep at the switch, or I don't know how they could have done this, but if they really thought that this was just like Jimenez, where liability and the medical expenses are uncontested, then it's a whole different thing.
I think the thing here is, as I said, the precedent in the fourth DCA seems to be the balancing of the two policies, and they seem to mostly favor only partial dismissals rather than unless it's completely egregious, as for example in Herman. They seem to favor partial dismissals, and actually this court also has in the past favored partial dismissals. Now granted, they were in discovery cases where perhaps it was the attorney who committed the discovery violations and they didn't want to punish the plaintiff. But
Well, that's a pretty material difference.
Yeah.
Wouldn't you say?
Yes.
Then,
But what I'm
it
saying
just
is,
sets that all apart from a plaintiff who just lies.
yes, Your Honor, but what I'm trying to get at is the fact that there is that initial understanding that some cases are subject to only partial dismissal and not the whole thing.
And
I'm
would
not
you-
saying that they were comparable.
And would you agree that the third DCA does not take this approach? Because Willie Kuntz, this was the very thing argued. They said these fraud doesn't touch these two separate things. Please, they shouldn't have dismissed the whole thing. And they did not apply a balancing test. They did not even mention it. They simply said, they used the abuse of discretion standard and said, we think a reasonable judge would have done a similar sanction, or we don't find it unreasonable, this sanction. So would you agree that that is not, while the fourth DCA might do that, that is not what the third DCA does?
No, the Willie Kuntz gives lip service to the fact that they did the balancing test, but they give us no facts about it, and they give no indication as to why they thought.
Does it even mention the balancing test? I don't know that it does.
I think they mention Jimenez, and
That's okay. You're good. You can keep
right.
going.
And
Question
they
on-
I think just
when liability isn't contested, why is that? Why would that be a basis to, only authorize a partial dismissal? I think you can agree, there's several cases where liability isn't contested, but you still get zeros across the board. So why even in that circumstance would it not be a legally permissible sanction to lying, to conclude that it permeates the entire case even when liability isn't contested?
well, it depends on the nature of the lie in those cases. How the lying affects all of the claims is fact intensive, and it depends on what the facts are. What did they lie about, and what is their claim? You do have to have an analysis of those factors. That answer.
Mm-hmm.
I have just enough time to thank you all for your time and to urge you to affirm the fourth DCA, and perhaps, if you are so inclined, maybe clarify the role of the balancing test against access to the courts versus judicial integrity. Thank you.
Thank you very much.
The court has been very generous with its time with me. And so I am disinclined to venture off on a series of commentaries. If the court does not have questions of me on rebuttal, I'll merely reiterate that the court should intercede here and fix the problem created by the 4th District's decision, which creates a horrible incentive for litigants to lie.
Do you prevail under the Willie Kuhn standard?
Yes.
Why?
I'm not sure I understand your question.
Explain. If the standard is the movement must prove by clear and convincing evidence that a party has sentiently set in motion some unconscionable scheme calculated to interfere with the judicial system's ability, essentially to find truth. How is it inevitable that you prevail? Why isn't that why is the 4th not within its power to say the trial court failed to do that here?
But the 4th didn't. The 4th concluded that the trial court correctly found that there was fraud upon the court, that it met this test.
Well,
and
it didn't apply this test.
Well, it references it. I think Justice Muniz
points You're going to take us right back to where we began, because then we don't have a conflict, right?
No,
Well, there's two tests. There's that, and then there's the balancing adjudication on the merits with access to the courts, right? There's two types of tests.
Yes, there are. And then the question of what's the correct test to apply in the last phase regarding the sanction, which is what I thought I had narrowly hoped to conscribe the appeal to. So,
but the balancing, I mean, so there's the factual question of what did the person do, right? Was there a lie? And then the balancing thing is just you could just sort of skip from, okay, I found that there's a lie, and then the judge is just kind of at sea as to, okay, then what do I do about it? The balancing thing is really just sort of filling in that middle step of, okay, well, now that I've found that there was this fraud on the court, how is my discretion going to be bounded? And it's just sort of trying to kind of summarize these categories of sort of what the criteria are. I mean, there has to be, I guess we could just sort of come up with a new thing that says all you do is you find if there was a fraud, and then the court just kind of does whatever it wants, and it just kind of explains itself. And then we just see if there's some sort of explanation that makes sense to the reviewing court. But I mean, you don't challenge. I mean, in your briefing, you say basically all the DCAs, everybody agrees that there is this kind of middle step of, okay, here are the things that are relevant to a court's consideration of what the sanction should be, right? So you're okay with that. And is there anything that you would add? I mean, the test, the way it's been described, it just sort of talks about, on the one hand, we got to think about, a person's right to their, a remedy, and then on the other hand, we've got to talk about the integrity of the judicial system. Is there anything else that should be added to that?
Well, I think, at the risk of waxing a little philosophical here, and this goes to the point my friend raised regarding the right to trial, the right to have a case decided on the merits. In the civil litigation context, a plaintiff who comes to the court seeking justice, seeking relief, inherently agrees to abide by the rules. Right? One of those rules is that you do not lie under oath. And so if you come to the court...
Well, that applies to both sides.
Oh, absolutely.
Not just to the plaintiff seeking it. That applies on the defense side, too. They're subject to the same rules.
Absolutely. And both sides have to play by the same rules. My point is that with respect to the plaintiff anyway, the plaintiff is actually coming to the court in starting the process. They are invoking the system. And to suggest somehow that anything you do within that process that is dishonest gets a free ride if you can somehow squirrel it away to some unique little bit, I think undermines the entire truth-seeking process, which gets back to this question.
This is why I wish somebody had briefed this as an unclean hands case, but all right. They don't pay me to do that anymore.
But there is that element to it, right? The right to trial can be waived, and it's waived frequently. And if you come into court and you say, I want relief from this system, and then you lie throughout the process, and when you're given an opportunity to explain yourself, you lie again, I think the work is done. The trial court, the trial judge, and they do this day in, day out in thousands and thousands of cases around the state, make these determinations, these tough choices. And I do not think it is appropriate for an appellate court that has agreed that there was this fraud, this scheme, this conscious scheme to cheat, to undermine the system. I do not think the appellate role is to say, well, yeah, but we think something else maybe should have happened. It creates horrible, horrible incentives.
You can have 30 seconds to finish up.
I want to thank the court for the time. This is a fascinating issue which has not visited this court in many, many decades. But it seems very clear that the outcome here is a terrible outcome, and it needs to be quashed, and it should be remanded with instructions to reinstate the entirety of the trial court's judgment. Thank you.
Thank you very much.